Is that a little better? Good morning, everybody. So, welcome to the committee updates. For those of you who don't know, my name is Logan Rathbone. This is Laura Oliver. We are the Family Law Committee co-chairs. We're going to do our update today in sort of a back and forth newscaster style. And so I'll just start by saying it's an honor and a privilege to be here back at plenary here in Windsor. Between spring plenary and now, a great deal of time has been spent by Laura and I working on a number of family law related written submissions, and so it was really, that took up a great deal of our time between the last occasion and now, so I think that a lot of our updates will be pertaining to that. But we also had the opportunity to be involved in certain consultations, mostly with the OCJ and the SCJ courts, so we'll provide some updates on those consultations as well. So over to you, Laura, if you could give us an update on our meeting. We recently met with the senior family judge of the UFC just over a week ago on November the 1st, so I think Laura has some comments about that.
Yeah, so the expansion of the UFC is sort of back in the forefront of people's thinking in terms of its sort of imminent. When you speak to the sort of people on the ground, like the OBA or the Advocate Society, there's a lot of, we hear it's coming, we hear Brampton is next. When you speak to either the senior family justice or some of the staff lawyers behind the scenes, they're like, not sure. So essentially what the judges and the staff are saying to us is, what has to happen is that, yeah, both levels of government are saying, yes, we support the expansion of the UFC, but there actually needs to be some mechanical communications in terms of how many judges are needed, and then get the federal commitment for that, and then on the provincial level, how many courtrooms are needed, what are the staffing needs, what does that cost, and the financial commitment on that, and then it can move forward. So that piece has not happened, although everybody is saying, yeah, we want to expand the UFC.
Fair enough. I think that that's something that Laura and I will have to put our heads together on a little bit in terms of how to rally up a little bit further support, particularly with the government. We were not, unfortunately, able to get a meeting in with the AG or a representative of his office, but I think we'll probably get to work on seeing if we can get back on the horse on that. I just want to speak a little bit about submission from July of 2023 that FOLA released to the Ministry of Children, Community, and Social Services. This is for the 5-year review of the Child, Youth, and Family Services Act, or the CYFSA for short. Now, as some of you may be aware, we at FOLA are going through a little bit of a transitional period right now, and we do not currently have an executive director. And so for that reason, the submission has not yet reached the FOLA website. But if anybody has not received a copy and would like to, feel free to send an email either to myself or Kelly, and we can flip that over to you. Just to briefly summarize some of the recommendations made. Firstly, that the terms custody and access should be replaced with decision-making responsibility and parenting time to be made consistent with provincial and federal domestic family law legislation. Some recommendations were made to clarify processes with regard to voluntary service agreements and temporary care agreements. It was further recommended that the controversial child abuse register be abolished. It's not an equitable system. It's no longer technologically necessary, given the technology that all children's aid societies in Ontario now have at their fingertips. And expunction hearings take up precious time and resources that we've better served by actually helping families and children. Fourthly, judges should have more discretion, in our view, to extend the statutory timelines that a child can be in temporary children's aid care before being forced to move forward to extended, i.e. permanent society care. Several recommendations were made with regard to First Nations, Métis, and Inuit issues in child protection legislation, including but not limited to closing certain identified gaps between the federal Bill C-92 and the provincial CYFSA. And lastly, it was recommended that the government review consider reviewing the extremely broad definition of parent under the CYFSA, particularly given the Court of Appeals' recent rulings that as the result of this ought to be that many, many more individuals should be added as parties to child protection cases that may not have been before. So that should be reviewed by the government, in our view, to determine whether this was intended or an unintended consequence. Did you want to speak, Laura, to the target benefit?
Very briefly.
Pension plan
So I
issue?
think at the last plenary, we let you know that we'd been asked to provide a submission on permanent framework for the valuation of target benefit plans. I didn't even know what that was at the time. And I had to look it up again today to talk about it.
It's complicated.
It's complicated, but our submission basically was that we wanted there to be transparency in the valuation process and that there needed to be consideration in terms of treating spouses equitably in if the plan didn't meet its target. So the response was positive and very, very technical and complex, and so we're going to choose to believe that they listened to us.
Yes, very detailed follow-up. Now, I just wanted to very briefly make our members who practice family law aware that we do expect some changes to the family law rules to be coming down the pike in the not-too-distant future. I'll put it this way. The Rules Committee has been somewhat tight-lipped about these changes, so there's not much more that can be said at this point. But based on our limited understanding thus far, the changes are not likely to be earth-shattering, but it's just something that practitioners should keep their eyes peeled for. And now, Laura, did you want to provide an update with respect to the Family Law Roundtable?
Yeah, so the Family Law Roundtable is something that I think the LSO sort of heads it up. And essentially what they've done is periodically they get together some people who have novel ideas for the delivery of family law services in Ontario. And we do it over Zoom, and everybody gives a short presentation in terms of, well, what about this or what about that? And so, for example, my what about was, why doesn't the Law Society have a family law clinic that is articles? And that, that kills a bunch of issues at the same time. And so the Law Society went, oh, that's a kind of a cool idea. Let's run with it. So if anybody has any novel ideas for the delivery of family law services in Ontario, by all means, please deliver them. We can try and get you an invite to the roundtable. So we have a meeting coming up on, I think it's the 29th, to follow up on all of the various novel concepts that the Law Society said, that's kind of cool, let's investigate it more. So at the next plenary, hopefully we'll have more to tell you. You can email me at Laura, Laura, at russolaw, russo.ca. All right, thank you.
And by the way, if you just look at the back sheet of the agenda, all of our email addresses are on there. So certainly, if there's any feedback that any of you folks would like to provide, feel free to do so. Just want to very briefly speak about a stakeholder meeting that Laura and I attended regarding modes of appearances in the Ontario Court of Justice for Family Law. So we spoke to this at the last plenary about the December 2022 meeting that we had. There was a follow-up meeting at the end of in July. And as a result of the follow-up meeting, as of August 29th, 2023, the official mode of appearance practice direction has now been posted. Now, it came into effect October the 10th, and the reason for that gap, according to the court, was to allow for enough time for people to adjust. I was going to walk you through a bunch of the changes, but I think I'll save you some of that sort of going through it too methodically. But it is not super easy to find online. What you need to do is you go to the OCJ website, you click Family, click Practice Directions, Notices and Guidelines, and then you'll find it. The confusing thing is that although we kept talking about it as being modes of appearances, the actual document is called Scheduling of Family Matters. So if you check that out, it will tell you what the changes are regarding mode of appearances. But bear in mind that it's always up to the presiding judge to go by a mode of appearance that they deem fit. And so how effective the actual practice direction will be, I think, will depend upon the jurisdiction, because at least in Halton, I haven't seen too many. The practical reality is I haven't seen too many changes, because we have two case management judges in our OCJ for family that tend to just do things the way that they want to do them, and so that remains to be seen. But I would certainly recommend checking that out if you get the chance, and if you do OCJ work for family law. I think that's about all we had. I just wanted to say. Oh, I'm sorry. No.
I had two
Laura
things.
Had more.
So
Go ahead.
Logan and I had a meeting with the government about the FRO. They responded back to us. They outlined their improvements, including FRO online, electronic service, and the statement of arrears calculator tool, which they believe are tremendous improvements to the FRO service. So if you or any of your clients have had any feedback with the FRO online materials, I would love to hear from you, because we are going to set up a follow-up meeting with them. And then lastly, we were asked to provide a submission on the inclusion of family law in the national requirement for accreditation. We did that. They got lots of submissions that family law should be mandatory, and the response was, let's think about that later. So we'll continue with that.
Yeah. So a lot of submissions, especially took place between last time and now. So we appreciate the opportunity to provide some updates with respect to some of those efforts. I just wanted to conclude by saying that Laura and I have found that we've actually gotten quite a bit of feedback from practitioners over the last year, and we always encourage those with suggestions, feedback, or just items people wish to bring to our attention to send an email, preferably to both Laura and me. And again, as I indicated earlier in response to a question, you will find our contact information on the last page of the plenary agenda. So thanks again on behalf of Laura and myself, and next we'll turn things over to Mark, who will provide our real estate update.
Thanks very much. So yes, Mark Giavedoni, Chair for Real Estate. The two overarching themes or issues since the last plenary. One is, of course, the passing of Jeff Lem, the Director of Titles, relatively unexpectedly and at a relatively young age as well. That left a bit of a gap at the top of the real estate conveyancing chain, although we understand that an announcement will be made imminently for an interim Director of Titles who was recently appointed for a 6-month period of time. Rather just wait for that announcement to come out, just in case the information I have is not right. So, because there's been some speculation about it anyway. So that might give some due leadership to the Director of Titles position. Keeping in mind that January 1st is the implementation date of the Law Society rule concerning validation of client identification. It's not just a real estate thing, it is a lawyer thing. It's a requirement across the board. Those rules, there's been a more active campaign throughout the province, and hopefully most of your associations, to re-engage our members about those obligations and requirements every time you're engaging with a client and every time you're engaging with funds in trust, with limited exceptions. So be mindful of those. Pick up some of the free CPD that's out there just to get familiar with it again, because it is a go for real this time, January 1st. MyTerrorview.ca is a centralized place to go to administer your TerrorView accounts as administrators, making it a lot easier to facilitate adding, modifying, or deleting accounts on your TerrorView licenses. So keep that in mind. There are ways to manage that online now. Just two plugs. One is that the use of the DRAs through the Law Society's website, those ones that have been endorsed, there's a multi-party DRA. Those are really, really helpful escrowing agreements that help facilitate transactions. They're still a surprise to a lot of lawyers. They're there, they're easy to use. Similarly, the working group for real estate lawyers, standardized closing documents should be used as much as possible. Lots of work has gone into them. I believe almost every law association has endorsed their use. So there should be some pushback on making sure that those are being used rather than whatever software your system is spitting out these days. And also to support the recommended fee schedule. Keep that in mind. There are some really handy tools on the working group's website to enable you to type in a purchase price and some other factors, and it'll generate what the suggested fee is. There's not a lot of pushback on that fee, and it is something that is a little bit more realistic. The second item that's been a bit more of a theme has been about housing. So what we've seen, and we've written some submissions in connection with the rise of vacant unit or vacant home taxes. Toronto has an existing bylaw, a bit of a fiasco. Ottawa has a similar bylaw, similar fiasco. Hamilton will have one imminently, going to be a fiasco. The issue behind it is that everybody who owns property has to submit a declaration to support whether or not it's vacant or not. So what the existing municipalities that have this tax are finding is that naturally not everybody who owns a property is submitting their declaration. So now there's a million people in Toronto that have deemed vacant units, and they have to go back through the process of applying and reapplying and objecting and appealing. And it's a bit kooky, as you can imagine, as you're facilitating real estate transactions and have to navigate if you've actually done your declaration or not, who's going to make the appeal or not, who has standing or not, where you make your appeal. So it's another example of really great idea that's gone without a lot of thought into how it's going to work out. Similarly, on the federal level, the underused housing tax came into effect, and so from 2022, those residents, non-resident citizens, and non-citizens that have properties that are underutilized or not utilized for the required portion of the year have to pay a tax. That reporting period has been pushed out twice. Now it's next April, because lo and behold, people aren't submitting their reports that they have vacant units or vacant or underutilized housing. So again, these tax regimes are coming in. They are consequential, and it's going to be up to lawyers and maybe some accountants to try and sort it out after the fact. Still grappling with the federal prohibition on the purchase of residential real estate by non-Canadians. This has been in force since the beginning of the year. It's causing more disruption in the more, particularly the jurisdictions where there's a close proximity to the U.S. border. There's a lot of U.S. citizens that have recreational properties in Ontario that, just a stone's throw away, and they're getting strung up significantly on these prohibitions. Some other ancillary consequences that, of course, didn't get thought through is that many other jurisdictions across the world have reciprocal agreements with Canada, such that if their national citizens cannot buy property in your country, you can't buy in their country. So something, for example, like Italy, you can't buy property in Italy now because Canada won't allow Italians to buy in Canada. So there's things like that that you're probably going to start seeing a little bit more frequently as people start to get deeper into the mix. We've also submitted some submissions to the province in connection with plans that they're tinkering with on new build construction limitations, consumer protection legislation, and enhancements to Tarion. So we've made those comments about builders that are canceling projects and what that leaves for deposits and protections and opportunities. The last item I wanted to bring up is with respect to the ongoing saga of Unity and the prices that are going on in connection with that. As you may know, earlier in the year, a class action lawsuit was commenced. There has now been a settlement in connection with it for a withdrawal of that action. That decision is available the decision recommends all of your members to actually review it, to know about it, and if they have their own issues, they're not precluded from pursuing their own independent action, but the class action is a no-go. So keeping that in mind, we've just submitted a real estate update, so the presidents and the real estate contacts in your associations would have received that yesterday, I believe. That's the report for now. And to Terry.
Thank you, and good morning, everyone. It's so good to be back here with you at another plenary. Thank you. I'm wearing this mask not because I think I'm sick. I think I ate something very disagreeable, but in this day and age, we wear masks out of respect for everyone else. So that's why I have a mask on. I don't actually think I'm sick. Now, this year, 2023, we had 15 minutes, and I was so excited. I have bullet points. I have a whole lay of the land that I'm going to report to you, and now I have less than 10 minutes, so here we go. I just have to throw the notes right out. Those of you who know me, I like to start off by understanding the dynamic of the room. Who in this room, if you don't mind raising your hands, practices legal aid for immigration refugee? Anyone? No one. This is the same answer I get at every plenary, I think. Family law on legal aid. Okay, we have quite a few here, thank you. And could you keep your hands up? Criminal law, add the criminal law lawyers who take legal aid. There we go. These are the people in the room who already know about the history. Now, we had the Attorney General zoom in, and he took some of my thunder and told you that you have not had increases in 25 years, other than the Criminal Lawyers Association Memorandum of Understanding with Legal Aid and the Attorney General back in 2010, just to give you a little bit of history. And then you had increases over the course of 5 years. So you have seen no rate increases since 2015. I know those of you who practice in the area, you already know about this. When we were at our plenaries, the last 3 at least, a lot of you, those who are here and those who went before you, were talking about a need to strike. They were talking about what's happened in the UK, what's happened in Alberta, and on the last occasion, people were really up to arms. You will recall that FOLA as a board reached out to all of you and asked the presidents of all the boards to have a designate on each of your boards who would be a legal aid point person that we could reach out to. Our next step was to have a province-wide legal aid committee meeting. Those of you involved know that meeting never took place, although it was anticipated. After the spring plenary, there was an emergency 8:30 in the morning meeting with the Alliance for the Sustainability of Legal Aid and all the various stakeholders, and I was there on your behalf. That particular meeting was where we received materials that we were not allowed to share, but they were coming from legal aid with respect to the proposed changes that came now into effect as of October 16 this year. Those of you working in the area, you're already well aware of the tariff increases, and that's good news. We got basically 10% between now and April, which is a significant increase. As you walk away from here today, it's really a question of, are you a glass half full or a glass half empty person? Because when you look at that history and you look at the increase is good. But when you look at the history and the dynamic of 25 years and the lack of increases, is it really good? That's a question that you can discuss maybe tonight when you go to the hospitality suite. Moving forward, I can tell you that ASLA had a meeting back in September. We continue to lobby. We continue to send correspondence to the government. We continue to look for a more stable mechanism to finance legal aid. It's difficult right now because we do not have that proper, I respectfully believe, infrastructure to support legal aid moving forward with the dynamic linked to interest rates, which can be very problematic as we've all experienced in these past years. Inflation, I believe, when I looked it up in April of 2023 was 4.4%. And yet, where are we with legal aid when our utilities are up, our staff definitely are up, everything, the cost of running the practice has gone up, and yet how viable is the current model? It's difficult, it's a struggle, and we need to continue to lobby, continue to have a voice, and continue to try to fix this, because as we all know, we are assisting individuals who need access to justice, whether it's in the family courts, in the criminal courts, immigration, refugee as well. People who otherwise could not find a route to have any access to justice whatsoever, but for legal aid, and but for your willingness to continue to accept legal aid certificates. So I encourage all of you to continue to have that heart for the people where you're willing to do that work, despite the fact that you're not necessarily recognized in terms of your remuneration. I had a lot more to say. Maybe we can just talk later, because I know Doug said he's going to claw back the time here, and so I hope I get some brownie points. There we go.
So-
Thank you very much, everyone.
So Terry, when we met with the senior family judge, she made a comment that from the bench's perspective, they see a real lack in young lawyers accepting legal aid, and wonder whether or not it's because senior lawyers are not too keen on it.
This is really good. It's actually a bullet point halfway through my second page. If you want to see it, I struck it out. But part of the difficulty right now is maintaining senior counsel on legal aid certificates, and also getting the entry-level junior counsel to engage. And it's not just, I don't think it's necessarily an attitudinal thing where the junior counsel are observing the senior counsel so they're following line. Sometimes it's the junior counsel who's training the senior counsel. Why would you do that? Why would you take those legal aid certificates? A lot of junior counsel are coming out and saying, no, thank you. I'll just take private retainers. And they're starting right from ground zero with a lack of willingness to take legal aid certificates whatsoever. Furthermore, legal aid, sorry, you got me on another little soapbox. Legal aid has created this infrastructure for junior counsel where you have to reach certain thresholds in order to be able to practice certain areas, which is healthy and very good, because it protects the public, but does it really, because now you have nobody and they're left to be a self-rep. And back in the day, it was far easier to become a panel lawyer, and with all the hurdles that are put in place to get to where the junior lawyers are saying, no, thank you, I'm not interested in that. And I'm told by junior counsel that they're coming, and I go to the dinners and I talk to them and I try to listen, and it's interesting, and I'm shocked. They're coming out with over $100,000 plus in debt. The interest rates are higher now. They can't necessarily afford to have that as their business model. So it's an interesting point where junior counsel maybe are following the example of senior. But I think more senior lawyers maybe are going to start following the example of juniors when they say, what do you mean you don't take legal aid? And it's a viable model? A lot of us at my generation, that's unheard of. Thank you.
Yeah.
I get a constant memo that says this is not what a client of reasonable means would authorize. When I have explained to you that my paralegal has worked for free on the files, that my assistant has worked for free on the files, and that I'm only billing like my limited time. So I actually just sent a very angry email to legal aid this morning saying that I'm done.
These are billing irritants. Billing irritants is on my list. It's always been on my list, and billing irritants continue. They're unbelievable. Not only at the back end, where half your bill that you billed, half gets clawed back. And I've gone to legal aid like you, and they say, That's your donation to the system, your paralegal, and that is your pro bono, but it's a forced pro bono. I know we're being recorded and I'm a little bit animated about this.
This
but
riveting
it's-
discussion, I think
it's
we'll have to
quite the
continue
issue,
over
and it's
dinner and
very
hospitality
problematic. Very problematic. And the fact, not just at the back end, a person of modest means. I once had a file where I made a huge charge where the guy would have gone to the penitentiary on a fraud. Legal aid told me I shouldn't have read all the disclosure. And that's in writing. Legitimately, a person of modest means would not have paid you. And I got the charge withdrawn without a preliminary hearing, without a trial. But a person of modest means wouldn't have paid you to read the materials. It's unheard of, and it's so subjective. And you've got me started on a whole nother, let alone all the authorizations and permission, the long line, and you can't bill for any of that. You can't bill for phone calls with legal aid, you can't bill for email. But the person on the other end, I'm pretty sure they're not going off the dock and saying, now, don't pay me as I'm writing to this lawyer. It's not, it's broken. It's broken. Thank you.